Good day. I want to talk with you about Fourth Amendment jurisprudence from a constitutional criminal aspect. We're dealing with the Constitution of the United States of America and the federal criminal procedure and those cases that impact upon the Fourth Amendment today. So we're talking about the language of the Fourth Amendment. My goal is to review the amendment and the applicable cases and see if we can tease out from those cases a set of rules, a set of procedures, steps, if you will, that we can practically apply whenever we're trying to decide whether or not a piece of evidence should be admitted or excluded at trial. My goal when we're done with this block of instruction is that you will be able to take it, use the analytical template that I provide for you, connect it to your knowledge of the cases, and be able to go forth and solve these issues in the real world. Okay. We'll start here with the language of the Fourth Amendment, and this comes right from the Constitution of the United States. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons to be seized. Now, I have highlighted various portions of this slide because I want to draw your attention to their connection to the substantive case law that follows and the procedures that we need to employ when we properly apply Fourth Amendment jurisprudence. You'll notice that we're concerned primarily with the security of the individual. This is an amendment that is designed to limit the power of the state to intrude into your private space. Now, they did not define it as privacy back in the 1700s. They go to the physical location, your person, your houses, your papers, and your effects. It's been subsequently defined as a privacy right and simultaneously as a trespassory right, and we'll talk about that. And the protection is only against an unreasonable search and seizure. And this means that some searches and some seizures are in fact reasonable. What's the test for reasonableness? Well, we look to see whether or not there is a warrant with probable cause supported by an oath or affirmation that particularly describes the person to be arrested or the property to be seized. Now, this is important because this concept of probable cause exists throughout the Fourth Amendment jurisprudence. And probable cause is something that individuals struggle with. It's somewhat amorphous from a definition perspective. You know it when you see it, but you're not always able to effectively apply it without having thought about it first. And what I want to do is to think about probable cause. I want us to think about probable cause together, not only from an arrest perspective, but also from a search perspective. So both seizure and search. And let's take a look at that. Here's probable cause to arrest up here on the screen now. Probable cause to arrest exists when I have facts in a set of circumstances that are reasonably trustworthy so that a person of reasonable caution could believe that the offense has been or is being committed. And that's language from a case. So what does it really mean in a nutshell? It means if a reasonable person applying a reasonable thought process to the evidence that was available to them would think, hey, yeah, I think that guy's about to commit a crime, that's sufficient to establish probable cause. And so probable cause could be, from a shorthand perspective, redefined as reasonable belief. You've got to have a certain quantum of evidence about the person and about the crime that's being committed. And that's sufficient for probable cause to arrest. And if I'm going to get a search warrant, I have to establish probable cause. I bring it to the magistrate. I swear that what I'm telling is true. The magistrate does a check of it, a judicial oversight. And if the magistrate agrees, they'll then authorize the search warrant. Now, we all know that many times there are exceptions to the need to get a warrant. We'll talk about those in a minute. But there is generally not an exception to have probable cause before the arrest is made. So probable cause becomes the linchpin around which all of Fourth Amendment jurisprudence revolves. And I have to understand probable cause and the things that can create it so that I can effectively determine whether or not the cops were within their rights when they go to admit or exclude evidence. So that's probable cause to arrest. Let's look at probable cause to search now. Probable cause to search is similar to probable cause to arrest. We're focusing on the knowledge of the police officer, and again, reasonable, trustworthy information that is sufficient in and of themselves to warrant a person of reasonable belief or caution to believe that an item subject to seizure is found in the place that they want to search it. So in other words, I've got the instrumentalities of a crime, the fruits of a crime. I know what it is, and I know where I think it is, and I have a reasonable belief that it's located in that location. That's probable cause. So I've got to show property subject to seizure, I've got to show that it's presently located somewhere, and that it's a place that I want to search. Again, sometimes I need to get a warrant. Sometimes I can dispense with a warrant because of the circumstances surrounding when the seizure occurs. We'll talk about those. All of these are, by the way, they're in a flow chart that we're going to discuss at the end of this presentation, and they're also in a series of numerical steps, an outline, if you will, of how you should proceed as you begin to analyze Fourth Amendment jurisprudence. Before we do that, though, let's look at probable cause and possible factors in evaluating the validity, if you will, of probable cause. Now, we've established that it's reasonable belief. And as we think about reasonable belief, in order to determine whether or not the belief is reasonable, there are some things that could be helpful to us. The reliability of the source of the information, whether or not the source of the information has some underlying motive that cuts against the person that they're providing information about. Factually, did they even have the ability to see what it is that they're claiming to see? This ability to observe. So if I'm concerned with reliability, motive to lie, and ability to observe, and for motive to lie you could also include just bias or prejudice for or against someone, then I've got to look at how they got the information. And by how they got the information, I'm talking about the police officer to whom the information has come. Sometimes they see it themselves. Boy, that's sweet evidence for probable cause. If a cop brings forward evidence that they themselves have observed, that's generally going to be enough for the magistrate. Sometimes it comes from another eyewitness. If it comes from another eyewitness, we've got to do a little bit more analysis. We have to dig a little deeper and look at that particular eyewitness in terms of whether or not they're reliable, their motive, and their ability to see what it is they claim that they've seen. We'll talk about the different types of eyewitnesses that happen. Sometimes a cop has rumor. They have a hunch. They have a guess, but they don't have probable cause. And that's where police officers get in trouble from the standpoint of attempting to manufacture probable cause that's actually not effective. And then occasionally we'll have hearsay statements. And what do we mean by hearsay? Well, every statement made by a confidential informant, an informant, or a third party is in fact a hearsay statement being given to the police officer that they want to then use to form the probable cause to get the warrant. The court is going to be concerned with the quantum of information. In other words, how much information did they have? The quality of the information that was provided. Think of this as the detail, and how correct the detail is. And then the timeliness of the information, because if the information is old, if it's already passed, if it's been overcome by events, so to speak, it's really not going to be useful to the police officer in getting probable cause. Now, once I've established in my head from a general perspective how probable cause works, then I should start looking at the two types of probable cause situations I have. And I've got them up here on the slide for you. One is to arrest, and the other one is to search. Probable cause to get a warrant to arrest someone, I have to show two things to the magistrate. I've got to show that a crime was or will be committed, and that the person that I wish to arrest is the individual who committed that crime. And I've got to show all that to the reasonable belief standard using the quantum, the quality, and the timeliness of the information. It's got to be information that there was a reasonable belief in its accuracy. Now, to search, it's a little bit different. Again, I have to show that a crime was or will be committed. But then I need to show that there's going to be evidence from that situation that is specifically related to the crime. Now, this could be in a stolen goods case, the goods that were stolen. It could also be in an armed robbery case, the weapons that were used, the information that was acquired. Think of it as the things that made it possible to commit the crime or the fruits that were received from the crime. If I've got either one of those, I'm probably going to be okay. And then finally, not only do I have to show that there was a crime and that there is evidence from that crime, but I have to show that I know that evidence is in a certain place. Because the warrant for searching goes with specificity to a particular location. Think about it for a moment. What a warrant gives me is the power to intrude into what is normally the right of an individual to be secure: person, papers, places, or effects. So I'm saying to the government, you are empowered to disturb, to pass over, to trespass into this person's personal space. We are obviating their right to privacy because of the probable cause that's been established. And so it's important that I get that right before the government does what it needs to do. So how do I get proof of probable cause for a warrant? Well, we've talked about the standard, but where does that actually factually come from? I mean, what really generates probable cause? If a cop says, "I saw," direct testimony of a police officer, giving sufficient evidence that a reasonable person would believe that the crime was committed, that's going to be enough for probable cause. It's going to be enough to go to a magistrate and get a warrant. It's also going to be enough in certain circumstances for the cops to take action without going back to the court and getting a warrant. And they'll be able to arrest or to search based upon that probable cause, given the circumstances, without the need for a warrant. Now, sometimes I have indirect testimony. I'll talk about indirect testimony in just a moment. Sometimes the reputation might be sufficient. Well, what would be an example? Certain types of places that engage in criminal activity tend to be arranged and to appear in a certain fashion. I want you to think about crack houses that you've seen on television with the boarded up windows. Perhaps there's a sign that is known in the drug community that here's a spot where you can buy drugs. One of the ones that's prevalent in the community where I live right now is a pair of shoes hung over a telephone line. That's an indication that drug deals go down within this area. If that's known by reputation and you can show that location to the court, that can be sufficient to get you a warrant. If someone admits that a crime was committed, in other words, a confession by someone, that could be sufficient. Circumstantial evidence. Maybe I don't have rumor, maybe I don't have a direct eyewitness, but I have lots of small things that when I bring them together in the aggregate through police work, leads us to believe reasonably that a crime has been committed and that a particular person committed it. And then sometimes circumstantial evidence plus the opinion of someone looking at it can be enough to push the court over the boundary into giving us probable cause to have an arrest warrant executed. Now, I mentioned in that slide up here indirect testimony and direct testimony. This slide talks about the different types of direct and indirect testimony. I want you to look at these four categories. They're important because different categories have a different impact on how the court is going to consider the probable cause that comes from them. If I have the victim in a particular case, the victim of a crime, a statement by the victim based upon their own personal experiences or observations is going to be sufficient to establish probable cause for an arrest warrant or a search warrant, with one caveat. If the victim happens to be a member of organized crime themselves, in other words, they're from a rival gang, a rival family, or they are themselves involved in criminal activity, we're going to want corroboration before we're going to allow probable cause to be established. Why? Well, think back to that very first slide where we talked about motive and bias to lie. Quite often, individuals who are involved in criminal activities themselves have a reason to either point the finger at someone else or to give the government something for their own benefit. So you've got to be aware of that. Neutral citizens. A neutral citizen is sufficient. No corroboration required. Cops are also okay. The interesting one is the fourth one down here, informants. Informants, by the way, are often used by law enforcement to ensure that they have an inside track into what's happening from a criminal perspective. And there are generally two types of informants that police use. One is an anonymous informant. I get a phone call, I get a tip. And another one is a known informant. And there are two different tests that are out there that address the use of these types of informants, and they both come from the federal case law. The first one is the Spinelli test, or the Aguilar-Spinelli test, as it's often referred to. And that's a two-pronged test, where we look at the status of the informant, known or unknown, and we look at the reliability of the information. That's an older test in the federal criminal law that's not always applied in the federal jurisdiction any longer, but is often applied in state jurisdictions. And so you need to know Aguilar-Spinelli for the background of how informants are dealt with. The current law, at least in the federal court, comes from Gates v. Illinois. And that case says that the law enforcement should look at the totality of the circumstances. Look at everything that's involved and the information that they got and when they got it and their ability to verify it, what's the same, what's different. And if in the totality of the circumstances I've got that reasonable belief, then I've got probable cause. What the Gates test did was remove from most appellate arguments the issue of the validity of information that came from an informant from a Fourth Amendment perspective. It was a very tricky and intelligent opinion on the part of then Justice Rehnquist. So I've got all this thought in my head. I've defined probable cause so that it effectively works for me. I've got the concept of reasonable belief, quantum of evidence, quality of evidence, timeliness of the information. How do I then bring all this together into a Fourth Amendment jurisprudence approach so that I can effectively decide whether or not a search is valid after the fact? Well, look at this slide right here. I've given you 6 steps that you should think about. First of all, who does the amendment apply to? Well, it applies to citizens of the United States, individuals who are here, who interface with law enforcement. The next question is, was there government action? We'll talk about that in a moment. Has there been an actual search and seizure? If there was that search and seizure, at the time of the search and seizure, did probable cause exist as previously defined? Was there a requirement that law enforcement get a warrant, or was there an exception to that requirement to get a warrant? When they conducted the search, whether they had a warrant or not, was the search in question reasonable given the information that was available to the police at the time? And then what do we do if there is a violation of the Fourth Amendment? And the answer is, if there is a violation of the Fourth Amendment, we exclude that evidence under the exclusionary rule, which is an entire piece of doctrine that is both connected to and separate from Fourth Amendment jurisprudence. So how do I sort these broad questions out in my mind? Well, I look at my list here. Who was conducting the search? What were they looking for? Did they have a suspicion? Why did they have that suspicion? Did they get a warrant? Where were they looking? So what do we mean by that? Let's say I've got a cop, he's walking down the street, he sees something happen that establishes probable cause that he thinks someone has let's call it a knife, an 18-inch big old pig-sticking knife. He sees this knife, and then the guy that he sees with the knife runs into a house. The cop thinks that the knife matches the description of something that had been stolen. So he follows the guy into the home, and he arrests the guy. The guy doesn't have the knife on him. Police officer is in this home. There's other people in the home. The knife he thinks is here somewhere. He can go and look in places where that knife might be and potentially have probable cause to do so. But what could he not do? Well, he couldn't open the pill box and go through the pills that are in the medicine cabinet. He could not go into the drawer where the socks are and unroll the socks to see if the knife is inside the socks. That's just one example of reasonableness versus unreasonableness of police actions. We could talk about others from the case files. So how do I sort through this stuff? Well, there's about a 6-question test that's very helpful. And I've got the first 3 on this slide right here. So take a look at it. We're talking about, is there government conduct, right? This is an important beginning point in your analysis. If the reason that law enforcement becomes aware of the presence of a criminal fruits of a crime, let's say, is because mom found the stolen stuff in son's room and mom turns it into the cops, it really doesn't matter whether or not mother had probable cause to search her son's room. Unless she's acting as an agent for the state at the time that she goes and looks, the government is not implicated. There's no Fourth Amendment analysis that's involved. I've got to have government conduct to kick off a Fourth Amendment analysis. Now, once I have government conduct, the next question that I ask myself is there a search and a seizure? Well, how do I determine whether or not taking custody of someone's body or intruding into someone's space was a reasonable or an unreasonable thing to do? Well, the court tells us, and they told us in Katz and in the progeny from the Katz decision, that we look at the reasonable expectation of privacy of the person who is being searched or who is being arrested. And that reasonable expectation of privacy is both a subjective and an objective test. We looked at whether or not the individual subjectively thought that they had a right to privacy, and then we look at whether or not society as a whole objectively believes that privacy belief by the individual is reasonable. Once we've done that, we then look for probable cause. So, government intrusion, expectation of privacy, probable cause. And as I think about probable cause, I need to define probable cause. Is it for arresting or for searching? Was there evidence there? Remember, I now know that the evidence, I need reasonable belief. And what test or factors do I use for probable cause? Think back to our earlier discussion where we looked at both probable cause to arrest and probable cause to search. These are the first 3 steps in any analysis of a potential Fourth Amendment issue in a criminal context. But they're not the only 3 steps. Look at the next 4, or the next 3. Was there a warrant for the arrest or search? If there was a warrant, did we have probable cause? Did the warrant appropriately limit the actions of the police based upon the information that was available at the time the warrant was executed? And then was the warrant executed properly? That's the 4th step that I have to look at to make certain that I'm okay from an analytical perspective. And once I've determined whether or not there was a warrant and was the warrant appropriately executed, I then look and say, okay, well, maybe there wasn't a warrant. Maybe because of the situation involved, it wasn't feasible. It wasn't possible for the cops to get a warrant in order to do their job. So I start looking at the exceptions to a requirement for a warrant when I want to arrest someone. And that's our 5th step. We've got it right up here on the slide. Was it a felony arrest in a public place? That's the Watson case. And if it's a felony arrest in a public place, I'm fine. I don't need anything further. I'm going to be fine from an analytical perspective. If it's a misdemeanor offense, as long as it was committed in the presence of the police, I'm going to be okay, and I'm going to be able to arrest the individual. I'm going to have probable cause to arrest, and that could even be for a misdemeanor offense that does not result in jail time. So, for example, the cops pull you over and you don't have your seatbelt on, and there's a statute in your state that says you have to wear your seatbelt, and it's a misdemeanor offense if you don't wear the seatbelt, the police officer can theoretically arrest you for not wearing the seatbelt, even though you could never go to jail if you were convicted at trial of not wearing the seatbelt. It's a little bit funny to wrap your mind around, but that's the extent to which this power of the police to arrest without a warrant is feasible. And now, of course, they're limited by procedures within law enforcement offices, but just because you limit someone doesn't mean they don't otherwise have the ability to do it if they want to. So that's the first 5 steps, and then let's look at the 6th step. Is there an exception to this warrant requirement? Because there are 6 of them that you need to be concerned with, and each of them flows out of the cases that have looked at Fourth Amendment jurisprudence, and I've got them listed here for you on the slide. They're not mutually exclusive from one another. What does that mean? It means that I could have one, I could have a couple, I might have 3 or 4, I might have one that straddles both. The first one is search incident to arrest. If I'm a police officer and I am arresting someone and that arrest is a valid arrest, I have the right to search that person for my own safety, for their safety, when I arrest them. And that right to search them extends to the area immediately around them when the arrest occurs. If they're in a car, when I arrest them, I can probably search that entire car. Now, if they are outside of the car and I arrest, and then I walk them over to their car and search, I might have a problem given some recent Supreme Court jurisprudence. But if I arrest them when they're in the car, I'm going to be fine. Sometimes I'm doing police work, I'll reach a certain point in my job, something's happening in my day, I don't really have probable cause to arrest someone, and then something happens. And when it happens, I have a case of exigent circumstances. Perhaps somebody runs by me with a bag of heroin, running down the street, laughing wildly, and I give chase as the police officer. They go into a home, and I follow them into the home without a warrant. Why? Because there's a good likelihood that they're probably going to flush that heroin down the toilet. They're going to destroy evidence. And if I had to go and get a warrant, it might take too long. It might happen if I'm knocking on somebody's window doing a door check at night for some reason. Knock, knock, knock. They crack the door open, and the fella who answers the front door looks like Cocaine Ricky. He's got cocaine circled all the way around his nose and mouth. His eyes are bloodshot, and he's just higher than a kite. And you hear him say, "Oh crap, cops!" He looks back over his shoulder and goes, "Get rid of it." Well, come on, that's an exigent circumstance. If I don't go in right now, those drugs are going to be gone. And in that set of circumstances, I can proceed without a warrant and do what I need to do, and I'm going to be fine because I've got probable cause based upon the circumstances in that moment. The trouble comes when the police officer tries to generate, create, fabricate from whole cloth probable cause when it's really not there. Believe it or not, that actually happens. Our third category are vehicles and container searches. Vehicles are not like homes. You don't have that same expectation of privacy because of their mobile nature and the fact that you use public roads to get around on them. So if I have my car and it's parked in my carport or in my garage, it's got the same expectation of privacy that my home has, or the curtilage around my home has. If on the other hand, I've got that car parked on the street, or I'm driving down the road, well, you can sell your soul to Jesus because you don't have an expectation of privacy at that point in the contents of that car. And if the police validly stop you, they're going to be able to look inside. The same for the containers contained within the car, depending upon the set of circumstances. And then sometimes inventory searches are conducted. You know, whenever you arrest someone and you take them down to the station for processing, one of the things that has to happen when you process them is that everything that is within their personal possession has to be cataloged and it's taken. Possession of it is taken by the police. So if you're wearing a gold ring or a diamond ring or a necklace, the cops are going to take that from you. They're going to properly annotate it on the inventory, and they're going to put it in the inventory locker. And you'll get it back when or if you are released from police custody. Well, what if that thing that they took from you turns out to be the instrumentalities of a crime from somewhere else? Do the police need to get a warrant to search your inventory bag while you're in prison or while you're in jail? The answer is no. Because that inventory was conducted for an administrative purpose, to ensure that your possessions were kept safe, there's no requirement for a warrant. There's no requirement for probable cause, and that evidence is going to be admissible. It's an issue that comes up from time to time. And then, of course, the next one, our fifth category, is consent. Police officers are trained to ask, would you mind if I looked inside your car? Would you mind emptying your pockets? Do you care about opening your trunk? Now, they're being polite, but they're not doing it to be polite. They're doing it because consent waives the Fourth Amendment right to privacy. Let me say that again. Consent waives that Fourth Amendment right to privacy, which means that if you have drugs in your pocket and you say, yeah, sure, go ahead, officer, look, you have just destroyed any Fourth Amendment issue that you might have. And it may be that there wasn't probable cause to arrest you at that point. Something to think about. And then the last one is plain view. Plain view is our sixth category for exceptions to the need for a warrant. What does plain view mean? Let's say the cop knocks on your door and says, ma'am, do you mind if we come in for a moment? We're interviewing folks in the neighborhood about the accident that happens down the street. Lady says, sure, come on in. You come in, and the cop, while he's standing there talking to the person who lives in that apartment or that house, he's looking around, and he sees, oh, I don't know, marijuana growing in a pot right out there in plain view where anybody could see it, in plain view that was seen by the police officer when the police officer was in a place that he was authorized to be. So if I'm the cop and I'm walking down the street and you've got your pot plants growing in the front yard, that's in plain view. If I'm walking down the street and I look into the windows of your car and I see a dead body, well, that's in plain view. The teaching point there is if you're going to kill somebody, make sure you hide them when you're done. In all seriousness, plain view and consent, those last two of our six exceptions, are ones that are routinely used by law enforcement, and they sort of grease the wheels of justice, well, at least most of the time. Now, that brings me to this flow chart. And this flow chart is a wonderful example of how we can properly look at Fourth Amendment jurisprudence. And the slide itself is extremely busy. But what I want you to do is to start in the top left-hand corner, in the yellow box, where it says government intrusion. And remember, government intrusion is the first question that we ask when we begin our Fourth Amendment analysis. If we don't have government intrusion, we're done. The Fourth Amendment is not triggered, there are no protections, and away we go. If we do have government intrusion, then we drop down immediately beneath it, and here you see a green box, and that green box says reasonable expectation of privacy. And I've got up here on the flow chart, it's both a subjective and an objective standard. And you'll remember the two-pronged nature of reasonable expectation of privacy, subjective belief of the individual and the objective belief of society. If I have a reasonable expectation of privacy, I've got to go immediately below it to the light blue box. And the question is, do we have probable cause? Probable cause to search or probable cause to arrest, and we look at the totality of the circumstances if we're dealing with an informant, and we look at the source of the information, the quality, the quantum, and the timeliness of the information when deciding whether or not we have probable cause. Now, if I have probable cause, the next question below PC is, did I get a search authorization and was it properly obtained? If the answer is yes, I'm all the way down in the bottom box, the red box, the evidence is going to be admissible. Now, we know, though, that most of the time I either don't have a reasonable expectation of privacy, I screwed up probable cause, or I didn't get a search warrant. And in each of those three instances, I wind up in the box here in the middle of the graphic, which are the exceptions to probable cause and search warrants. And I've got them listed here for you. Search incident to apprehension, we've already talked about. Inspections, border searches, inventory, sobriety checkpoints, employee searches, and medical purposes, those are all examples of where the police are acting in their administrative capacity for the health and welfare of society, and we focus on the purpose of why they were doing that. And if they were doing it in accordance with an established procedure and not as a subterfuge to get around the Fourth Amendment, what's discovered is probably going to be admissible at trial. And then I've also got up here stop and frisk. Stop and frisk is interesting because stop and frisk is that in between the cop thinks nothing's going on and probable cause. They sometimes have a concept called reasonable suspicion, where their intuition, their hunch tells them that they think this individual may have been involved in something inappropriate. Perhaps they're concerned for the safety of the officer. Perhaps they're concerned for the safety of the folks in the immediate environs. And what reasonable suspicion gives me, and it comes from Terry v. Ohio, that particular case, it allows the police officer to minimally intrude into the life of the individual to make certain that they're safe. It's often referred to as stop and frisk, to make certain that there's not a threat. The interesting thing about reasonable suspicion is that if something further happens while they're stopping and frisking, I may shift into full-blown probable cause. So it becomes an intermediate stepping stone to probable cause when I don't first have it. And we've got it up here on the slide. And then, of course, I've already talked about exigent circumstances and the automobile exception. If I don't have any of that, I may still be able to admit the evidence. The police could have screwed up reasonable expectation of privacy. They could have made a mess of probable cause. We go to the exceptions, and their exceptions don't work. But you know what? If they fall into one of the categories of the exclusionary rule, we can still make that search a valid search. We can still make that arrest a valid arrest and admit the evidence at trial. And these exclusionary rule exceptions are in the green box over here down on the corner. And what exclusionary rule exceptions for right now, and we'll talk about it in a different presentation, there's the good faith basis, independent source, inevitable discovery, attenuation of the taint, and for impeachment purposes. The idea behind the exclusionary rule is that sometimes, even when the cops violate the Constitution, there are sufficient intervening factors that so attenuate, remove the taint, or just we would have found out anyway, that it wouldn't be fair to not allow that evidence to be admitted at trial. And this is often referred to as the fruit of the poisonous tree doctrine. The idea being that the exceptions to the exclusionary rule wash the poisonous fruit, the fruit that has been poisoned by the improper actions of law enforcement, allowing it to be eaten, consumed by the court, presented to the jury, used as the basis for conviction. And it's only when all of those don't work that I finally get to the light blue box up here on the right-hand side, and I actually exclude evidence at trial. What does this tell you in a nutshell? It tells you that in a nutshell, there are multiple opportunities for the prosecution to admit evidence that was initially obtained in violation of someone's Fourth Amendment right. And that it is a dance, a sequential steps, if you will, a waltz, a foxtrot, a quick step. I guess it depends upon the judge that you're in front of, where we come to the conclusion that the evidence will or will not be excluded. If you use this flow chart and the 6 steps that I identified previously, you're going to be well on your way to properly analyzing these sorts of questions in the context of any criminal representation. Now, we've only talked about the Fourth Amendment here. At other times, we'll talk about the Sixth Amendment, we'll talk about the Fifth Amendment, and we'll talk about the impact and the connection of the exclusionary rules with all of those. Till next time, I'm Professor Rose. I'll see you down the road.